Okay. Good afternoon. We're on the record. If you could please state your appearances.
Hello, Your Honor. Bob Cercio, CER, CEO, bar number 5247. With me is Mother Christy Baugh and our new associate.
Leonor Falyan, URFALYAN, bar number 14636.
How do you say your last name again?
Falyan?
Okay. I'll ask you again probably. Nice to meet you. Good afternoon, ma'am.
Good afternoon, Your Honor. Alex Kibato, bar number 10592, on behalf of Andrew Baptista, who's present.
All right. Good afternoon, sir. So we're set for trial.
Yes, Your Honor. A little bit earlier today, I received a call from Mr. Gibato. Mr. Gibato, asking for continuance. I don't have authority to proceed. He was just hired on Tuesday. However, he's got health issues. And what I do not want to have happen is to swing open an appealable issue based on the health of counsel. We are also set for tomorrow morning. Let me give you some of the things that we've spoken about. We can do some of the administrative things today, some straight stipulations to streamline what happened, how we proceed. And then we can also go with a half-day setting, timed 2 hours per side, inclusive of opening and closing arguments. And so we don't need to do a full day. So,
I'm sorry. Will you repeat that?
sure. What's being
2 hour part. I'm not sure.
Because of the health issue,
Uh-huh.
we're concerned about that might give rise to a possible appeal issue.
Mm-hmm.
And what the Supreme Court would do with that, who knows? But
Oh, no, I agree with that. I'm talking about, you said something about 2 hours.
What opposing counsel and I have been discussing is on the reset for a half day, 2 hours per side, not a
Oh,
minute
okay.
more.
Now I
And,
understand. Thanks.
And that would be limited, that would be inclusive of opening and closing arguments.
Okay, that would include everything.
Yeah.
2 hours each. Okay.
And the other thing is, and discovery's still closed. There's also, Mr. Gabato might have some ancillary witnesses, what we sometimes refer to as the 10-minute witnesses. I've asked them to just put those in a letter and to make an offer of proof as to what each of one of those witnesses is, and if I can accept the offer of proof, those are witnesses that we can wipe off the table, and we'll just give you a formalized stipulations or findings on those.
Okay.
We went through the exhibit book, our proposed exhibit book. They're prepared to permit that to be admitted.
In total?
In total, reserving for weight. Some of these are demonstrative. For example, the exhibits 1, 2, and 3 are the Missouri orders brought forward, so those don't technically need to be admitted because they're part of the court record. And 9 is various photographs. The photographs would just be demonstrative. I don't even know that I would use them. But everything else would just come in and would go to weight for your consideration. That would also streamline the proceedings so that we're not arguing about the technicalities of getting there's only 11, and actually once you straighten that down, it's more like 7 exhibits. There's also some stipulations that would naturally be brought forward from August 31, and I'll just say those out loud. I went over them with Mr. Gabato. First, of course, is paternity and the child, her date of birth, that there's been no objection to the domestication of the Missouri orders, that this court has conferred personal and subject matter jurisdiction over the parties and the child. So we have UCCJEA and UIFSA jurisdiction to go forward. He made a finding under Rooney that there was adequate cause to go forward. That was confirmed by both counsel. Then we jumped down to unreimbursed medical expenses, just using the simple 30-30 rule that we always employ. And also bringing forward into the final order the neutral behavioral order, which is basically be decent to each other order. So those are the stipulations the prior stipulations that would be brought forward. So given that, again, I don't have authority, but I've tried to outline as cleanly as possible to give you your maximum options if it's your desire to continue the matter.
Thank you.
Thank you, Your Honor. As I had indicated in the past some occasions, as recently diagnosed with cervical degenerative arthritis in the spine, cervical spine. It flares up from time to time. It's excruciatingly painful. It radiates down my left arm. My leg today is when it happened, and it's the position that I'm in is I either sit through a trial in abject pain, or I take painkillers and my judgment's clouded. So I prefer to pass it. What I wanted to do, if the court can pass it as he stated, we agreed to do a half day sometime in the future rather than have the hearing tomorrow, because I prefer to just sit in my bed for the remainder of the year and try to get some rest. So with that,
Okay.
if the court wants proof of the condition that I have, I can certainly provide it on camera.
We take counsel's word on that. There are two other things. There are two other things I just wanted to mention real quickly. Because we're through the holidays, we would propose, just as a temporary measure, to use the court's default grid for the remainder holidays as we go forward between now and the trial date.
You mean next week? You don't know what's
Oh,
going to happen next week?
No, we're good.
I'm talking about, okay, so you're fine for this
We're covered
coming
for
up.
Christmas. We're just talking about
If this goes
2018.
past and into, if the date you give us is, if at some point we reach some holiday like spring break, for example, we're going to utilize a default holiday schedule.
The other thing we would like to do is, the lottery for the charter school is coming up, and this is not binding upon choice of school, but we would like to participate in the lottery for the charter school. There's one that's located near both parents' house, and we would just simply make the application, see if we can get in on the lottery, but we don't have to commit, so there wouldn't be immediate change in the child's school. Just the option would be preserved.
I was listening, I was just asking something. Okay. All right, well, if counsel doesn't feel well, I certainly don't want to put him in a position of having to take pain medicine to go forward with the trial. That's not appropriate. So, given his health issue, we're going to grant the continuance. It's the first request for a continuance also. And, so yes, it's open the 26th? Yes. So we had something come up on February 26th at 9 a.m. That would give us plenty of time because we'd have the full day.
February 26th?
It's a Monday.
Yeah, I'm available. That's the same week as the Bishop CLE.
Is it?
Sometimes.
Oh, at the end of the week.
Correct. And I know that the AOC sometimes does the judicial training.
I'll be here.
Oh, okay. Well,
Thank you for letting me know. I appreciate it because I'll forget.
just trying to.
I forget sometimes, but this year I'm not going to go.
Got it.
I'll be here. So that state's fine for you too?
Yes, Your Honor.
All right. So February 26th at 9 a.m. I understand you're trying to limit yourselves to 2 hours each, which is great. But if we need a little extra time, we have it.
So we'll call it a soft 2 hours.
An attorney 2 hours.
Attorney.
Like an attorney
Got
5
it.
minutes.
Got it.
All right.
And what I'd like to do from today, so that we don't lose any progress that we've made, I'll prepare the stipulations that we're carrying forward. I would propose under
That you
EDCR
just put in.
7.50,
okay.
put them in on the record. I'll prepare an order from, we'll call it status hearing, for Mr. Gilberto's counter signature, and it'll just be a repetition
That's fine.
of the terms that we spoke about.
And you agree that they're binding under 7.50?
Yes, Your Honor.
Okay. All right. Well, I wish you all the best of holidays, and I hope you feel better.
Thank you, Your Honor. Same to you.
I'm sorry? If they want it, they can have it.